All right, good evening, everyone. Welcome to the Center for Studies in Religion and Society's public lecture series. My name is Kathy Chan, and I am the acting director of the CSRS for the 2022-23 academic year. I'd like to open tonight's lecture by acknowledging and respecting the Lekwungen peoples on whose traditional territory we are holding this lecture series, and the Songhees, Esquimalt, and Wasanich peoples who have continuing historical relationships with this land. I'm grateful to be living and working in these territories. And I'm very pleased today to introduce Dr. Brian Bird, who has crossed the Salish Sea to be with us tonight. Dr. Bird is an assistant professor in the law faculty at the University of British Columbia. He is an alumni of our own law faculty, with degrees also from McGill and the University of Oxford. He studies constitutional law and theory and the interactions between courts and legislatures, and is a leading Canadian authority on the scope of freedom of conscience under the Charter of Rights and Freedoms. And I look forward to hearing his thoughts tonight, as I'm sure you all do, on the freedom of elected representatives to vote on legislation in accordance with their conscientious convictions. Welcome, Brian.
Thank you. Thank you. Thank you so much. Thank you so much, Kathy, for Professor Chan, for this very kind invitation. When you issued it to me, I think it was probably last summer we got in touch. I was very happy to receive it. Thank you to the organizers, to the center, to Scott, to everyone who's involved in making this come together. And thank you to all of you who are both here in person and online. It's just a treat for me to be here, especially because this is where I studied law, where I went to law school, and now it feels, well, it's more than a decade ago, certainly now. So I have a very special place in my heart. This university has a special place in my heart, and it's just wonderful to be here, especially thinking of professors who, from this law school, from this university, who inspired me to think about these topics, including the topic that we're going to be speaking about tonight. So it's wonderful to be here. Thank you so much for joining us. Today, before I kind of dive into the topic of the freedom of lawmakers, of politicians to exercise what I term as conscientious representation. Might be good just for me to mention that my doctorate was on freedom of conscience under the Canadian Charter of Rights and Freedoms, which is guaranteed in Section 2A of the Charter. That provision of the Charter guarantees freedom of religion, freedom of conscience and religion. So two guarantees built into one, conscience and religion. Freedom of religion, since the now more than 40 years since the Charter arrived, has received a lot of airtime, so to speak, in the courts, in jurisprudence, whereas freedom of conscience really has been kind of a forgotten charter freedom. There's very, very, very little out there on what that charter freedom looks like. And so when I embarked upon my doctoral work several years ago, I thought, well, here's a really kind of fertile ground for exploration. And one of the topics I wanted to look into, or was always fascinated to me, is the freedom of conscience of lawmakers, of politicians. But it didn't really fit in the project I was doing for the doctorate, because the Charter of Rights and Freedoms binds the state in terms of how it relates to citizens, in terms of the laws that it passes, the actions that it takes. And then the question is whether those laws, whether those actions of the state respect the rights and freedoms that are guaranteed under the Charter. When we're talking about politicians as members of a political party who are told by their leader of their political party that they have to vote a certain way or have to toe a certain party line, the Charter isn't directly engaged, because it's not, even though you might have the prime minister or leader of the official opposition, who is of course, exercising a public function, what they're wearing at the time when they tell their party members, their caucus, to vote a certain way, they're telling them with the hat of their political party leader on. So the Charter isn't directly applicable in the same way as it is when we're talking about a law that's been passed by Parliament that might infringe a particular charter right or freedom, or an action by a state actor, say an administrative body, that might impinge a charter right or freedom. So I had to leave this topic out of my doctoral dissertation because it just didn't fit super or perfectly well with a charter discussion. But I think it is a worthy topic to discuss nonetheless. So it's a bit of a foray for me, a legal scholar, a constitutional scholar, into political theory. So please forgive me in advance for stepping a bit out of my lane. So with that, I'll dive in. So in Canada, as with many other liberal democracies, lawmakers are generally expected to vote on proposed legislation according to the position of the political party to which they belong. And where lawmakers refuse to toe the party line, punishment by the party, often termed party discipline, may follow. Party discipline can take a variety of forms, up to and including ejection, removal from the party. On rare occasions, though, party leaders will forego party discipline and instead grant what's often called a free vote on proposed legislation. And where that freedom is granted, lawmakers can vote as they wish without fear of being sanctioned by their political party. And so I argue in this presentation, and this presentation will be published as part of a collection on conscience rights. It's coming out this year, I believe, in the Supreme Court Law Review published by LexisNexis Canada. So I argue that elected representatives in liberal democracies such as Canada ought to be afforded far greater freedom than they currently have when it comes to how they vote on legislation. Free votes, in short, should be, in my view, standard practice in all liberal democracies. And I pursue this claim because this freedom, in my view, first of all, respects the complexities that confront elected representatives in their work in a liberal democracy. Secondly, it reflects the close relationship between lawmaking, and normative considerations. And thirdly, this freedom facilitates robust debate on issues that are proposed to form the substance of legislation and thereby influence the shape and trajectory of a society. So this presentation, I should note, is inspired first and foremost, or most immediately, by the situation in Canada when it comes to the state of party discipline and party politics. Though I think it will also be of value to other liberal democracies in the Commonwealth, in the United States, Europe, and beyond. Now, I do not identify the precise similarities and differences in how party politics and party discipline operate across jurisdictions due to variations in political and legal systems, but it seems to me, even so, fair to suggest that all liberal democracies suffer, at least to some degree, from a democratic deficit, owing to the embedded nature of party loyalty in their respective political cultures. In other words, despite the differences between the world's liberal democracies, I seek to propose or to set out a common standard for what, in a very fundamental kind of bedrock sense, representation should look like everywhere. And so in a nutshell, I propose that free votes and the related freedom to express why legislation should or should not be enacted goes to the heart of what it means to be a representative in a liberal democracy. And for that reason, every vote in a legislature should be free. So we'll go through these three topics that I have in mind as to why I think this freedom is worthwhile pursuing. The first is the complexities of representation, the complexities of that role. Viewing free votes as the rule rather than the exception, a view that is the opposite of the status quo in many liberal democracies, understands elected representatives as trustees of their constituents who exercise independent judgment and rely on conscience. So a famous proponent of this view, this trustee model, was political theorist Edmund Burke. He defended this model of representation in a speech that he gave after his election, immediately, I think on the night of his election to the House of Commons in the UK in 1774, in which he called for a careful balance between loyalty to one's constituents, conscience, and country. While lawmakers, he said, must generally prefer the interests of their constituents to their own, the interests of their constituents, he said, must be afforded great weight. They meaning lawmakers, must neither sacrifice their conscience and judgment, nor give effect to an opinion from constituents that is evidently opposed or opposite to the real good of the rest of the polity. And so this speech by Burke, it's a very short speech, the speech to the electors of Bristol, given in 1774, invites us to consider, or invites consideration, of the inherent complexities of democratic representation. The prevailing model of representation today seems to view representatives as agents or delegates whose mandate is to enact either the manifesto of their political parties, the wishes of their constituents, or some combination of the two. Now, this model is indeed and maybe straightforward and efficient and kind of simple to approach, but it fails in my view, or it falls short to account for a host of scenarios that regularly arise for elected representatives. One of these scenarios is where the position of the lawmaker's political party deviates from the interests and wishes of the lawmaker's constituents. A related scenario is where the party's position once reflected those interests and wishes, but has since evolved and now deviates from them. The party's position may not be contrary to the interests and wishes of the lawmaker's constituents, but it might nonetheless fail to account for the experiences and knowledge that members of that constituency can bring to bear in respect of whichever policy issue is on the table. The agency model of representation, the current kind of prevailing model of representation in most liberal democracies that emphasizes party loyalty or loyalty to party leaders, is effectively silent on how the lawmaker is to relate to the constituents who did not vote for the party to which the lawmaker belongs. And finally, the lawmaker might even agree with most of the party's manifesto, his or her party's manifesto, but could disagree with a small portion of it. It seems fair to surmise that few politicians agree with every sentence of their party's election platform. Yet the agency model, it seems to me, doesn't grapple with that reality either. Instead, this model expects, or seems to expect, that the representative will toe the party line even if the representative opposes it. Now, I should note that to question the agency model, or to kind of put it to the test, to question this model of representation is not to dismiss the important contributions of political parties in liberal democracies. These organizations craft their policy positions based on what they believe will serve the common good and the public interest. Parties have generally proven to be effective in achieving policy goals and stable governance. Political parties have been effective in mobilizing citizens toward common ends, and they often enrich political discourse. In terms of efficient and stable governance, political parties have obvious benefits. But party discipline can also, at times, stunt representative democracy. This approach can create barriers for citizens when they seek to have their concerns meaningfully heard by lawmakers. When their representatives lack the freedom to fully consider their concerns owing to where the party stands on the issue, no matter how compelling these concerns might be, there is, I think, an inescapable loss for representation. Where the representative believes that the party's position on a particular issue is fundamentally incorrect, but opts to abstain or even vote with the party due to the specter of party discipline, representation also suffers. It's not difficult to imagine how strict party discipline might also have an exclusionary effect, both on persons who seek elected office and on voters. This effect, or that effect, that exclusionary effect, would seem to be acute in democracies where long-standing political parties have dominated the halls of power, such that it is exceedingly difficult, maybe even practically impossible, to be elected as an independent member without party affiliation, or to succeed in creating a new political party. And so when a feature of democracy creates formidable, in some cases even seemingly insurmountable barriers to democratic participation, that feature of a democracy might actually be a flaw. Political parties, they form around a set of principles, it's true, but coerced conformity with them at all times and without exception is not, in my view, a prerequisite for parties to flourish. So in Canada, for example, strict party discipline, and we would, I think it's fair to say, comparatively speaking, have one of the strictest or most stringent forms of party discipline compared to other liberal democracies. The strict party discipline in Canada did not emerge until the latter half of the 20th century. The experience in other countries supports the view that a zealous approach to party discipline is not essential to the proper functioning of political parties in a democracy. So for example, party discipline also exists in the United Kingdom, but certainly with less intensity than in Canada. Even in the United States, where party discipline is even more relaxed in a certain respect, loyalty is not considered to be in short supply. Party loyalty, that is. Now, critics of conscientious representation, or to put it differently, the trustee model of representation advanced by Burke, might argue that this approach, the trustee model, conscientious representation as I call it, they might argue that this approach betrays citizens who vote for a particular party and the policy commitments that the party has made. These citizens, so the argument goes, chose a specific party at the ballot box and reasonably expect that the person representing that party will implement that party's platform. This is essentially, I think, an articulation of the agency model of representation, which I am trying to suggest, at least, or propose, is democratically deficient, or at least has some democratic deficiencies, and ought to be replaced with a trustee model, or at least replaced with something closer resembling that model. Even so, as mentioned before, it's not a far-fetched possibility that the advantages of the agency model would largely actually remain intact, even if this replacement were to take place. So individuals who, for example, individuals who seek public office as a member of a political party would, I think, in most cases, vote in keeping with the position of the party on any given issue, even if we moved towards conscientious representation. I'll explain why in my view, a bit later on. Indeed, in jurisdictions where party discipline is less stringent than others, say the United Kingdom compared to Canada, party solidarity does not appear to suffer to any appreciable or major degree. The decision to break ranks, when it occurs, would be made only for compelling reasons, such as where politicians believe that towing the line would harm the common good or the public interest. Another argument that critics of conscientious representation, or the trustee model, might make is that adopting this model of representation would actually hinder efficient and effective governance. The argument, in other words, posits that governments will achieve fewer legislative results, and perhaps fewer legislative results of quality, if party discipline is largely abandoned. But this fear, again, doesn't seem to be well-founded, considering what the experience has been in jurisdictions that are known to feature a more forgiving form of party discipline. It would be challenging, for example, to argue, I think, that the United Kingdom or the United States fail on very basic metrics of governance, as opposed to countries such as Canada or Australia, where party discipline is more stringent. While there's no denying that strict party discipline leads to fewer surprises in the legislative process and thereby increases efficiency in a certain sense, the losses in this regard, where party discipline, or the losses where party discipline sits closer to something that could be termed party expectations, seem to be unremarkable. When one balances the negligible sacrifices in efficiency and administrative ease against the gains in terms of better embodying the aspirations of representative democracy, I think the case for conscientious representation becomes more compelling. Now, conscientious representation, as compared to the current prevailing agency model, adheres more closely, in my view, to the true nature of representative democracy. In this form of democracy, citizens choose fellow citizens to represent them and their interests in a deliberative legislative assembly. The agency model, I think, oversimplifies the role of representatives, perceiving them more so as kind of robots that generally do the bidding of their political leaders. In many respects, the agency model and the rather unchecked form of party politics that it tends to generate places representative democracy arguably on its head. Instead of the voters being the driving force of a democracy, the leaders and power brokers of political parties assume this position. And again, political parties play a valuable role in representative democracies, and the choice of voters to support one party over another is significant. Even Edmund Burke said that the views of the constituents are supposed to take great weight, or receive great weight, but it does not resolve the other nuances that can arise in the work of an elected representative. Darren Jensen, in the closest that I have found to a focused study of the relationship between free votes and representative democracy, argues that if representatives are meant to be our representatives for the purpose of deliberating about whether legislative measures are the right measures in terms of the general good of the community, conscience votes are an essential element, then, of the legislative process. The claim that free votes flow from understanding representatives as deliberators of the common good, a claim that kind of echoes Edmund Burke in a way, will be taken up in the next portion of this presentation. So after moving from the complexities of representation, which I think conscientious representation resonates more with, at least compared to the agency model, we move to this second reason, or second section, as to why I think greater freedom of conscience should be afforded to representatives. And that is this idea of the normativity of lawmaking. So the traditional approach in many liberal democracies, especially in democracies that follow the Westminster parliamentary system, has been to identify legislation that features a conscience issue on one end, or one side, and legislation that does not feature a so-called conscience issue. If the legislation features a conscience issue, The leaders of political parties may or may not allow their members, their caucus, to vote freely on the legislation. If the legislation does not feature a conscience issue, the members are expected to vote in line with the position of the party on the proposed legislation, and if they don't, there will be some sort of sanction or discipline. What then, this raises an interesting question, what then, properly understood, constitutes a conscience issue in the legislative sphere? Now, conscience is a topic of long-standing philosophical treatment, can be described, just one description, one offering in this regard, can be described as the sense of right and wrong that governs a person's thoughts and actions. Conscience issues that have attracted free votes in liberal democracies have been described as social questions which have strong moral overtones and which call for a moral judgment of right or wrong. They are usually deeply contested and controversial issues about which individuals hold strong beliefs. Perhaps the most familiar conscience issues addressed by legislation concern life and death, issues like abortion or euthanasia, capital punishment, for example. And I should just note here, in my work, my doctoral work on freedom of conscience, one of the things I did in my doctorate was try to define freedom of conscience. What does freedom of conscience protect, at least in the context of the Canadian Charter? And I take the view that basically it protects one's moral convictions regardless of where they come from. So whether it comes from the moral teaching housed within a religious tradition, or it comes from the moral teaching housed within a secular worldview, I think that the bottom line is that those two, the bottom line would still be a conscientious conviction. So in other words, if you're someone who opposes war and thinks that war is immoral and you refuse to bear arms, let's say if conscription occurs and there's a draft, whether you arrive at your conviction regarding the immorality of war through religious formation or through a kind of a secular worldview, you would be equally protected by freedom of conscience. Whereas freedom of religion, in my view, is much more focused on, for lack of a better way of putting it, theological teaching or faith-based beliefs. So the version of conscientious representation that I propose in this paper, turning back to our topic, rests on a premise that departs from the traditional approach to free votes described above, this approach of trying to categorize, okay, we have this piece of legislation on whatever topic it might be, is it a conscience issue or not a conscience issue? And depending on where we go in that regard, we have a fork in the road and that determines whether we might have a free vote or not. My view holds that representatives, elected representatives, must actually conscientiously assess every legislative measure against the standard of whether it serves the common good. Whether the legislation concerns euthanasia, income tax, trade, or crime, the representative must always determine whether the legislation serves to benefit the polity to which it applies. Conscientious representation, in other words, transcends the distinction between legislation that engages a conscience issue and legislation that does not. So, in other words, granting lawmakers the freedom to vote according to conscience, I think actually harmonizes with the notion that lawmaking is inherently normative. While the traditional approach, this kind of, is it a conscience issue or is it not, has been to identify legislation that engages conscience and legislation that does not, the reality is, in my view, all legislation, every piece of legislation, no matter how mundane, engages the conscience, or should, I hope. I think we hopefully would all hope that it should engage the conscience of the representative. The question of whether the legislation at hand, whatever its content, whatever the issue might be, betters or betrays the common good, inheres in legislating, regardless of the content of legislation. So to kind of really put it pointedly, every vote in a legislature, in my opinion, is to some degree a matter of conscience. Legislating for a society is inescapably infused by considerations as to whether proposed laws serve the common good or not. Owing to the unique capacity of law in societies that adhere to the rule of law to shape our moral ecology, as I've heard one author put it, legislating for a society is always a normative endeavor. The persons charged with carrying out this task in a representative democracy are thus situated at a unique juncture. They must evaluate in a normative fashion the merits and demerits of all proposed legislation. So in other words, a major flaw, in my view, in the discourse and scholarship on legislatures is this dichotomy between what is usually a very, very small set of so-called conscience issues on the one hand, and most of the other issues that are said not to implicate conscience. But as I've tried to make the case here, legislating is, on the contrary, always a matter of conscience. This notion is certainly more accessible depending on the substance of the legislation. I grant that. Certain areas of law, from employment standards to the law of negligence to human rights codes, more immediately engage with normative considerations. Constitutional law is often imbued by commitments to moral principles and ideals such as freedom, equality, and human dignity. Even so, I still believe that with every piece of proposed legislation, no matter how mundane the substance might be, the basic question for an elected official is whether the legislation is, normatively speaking, in the best interests of the society that will be governed by it. Legislatures decide how a society will be governed and the rules that will bind citizens. At times, rules that will, if broken, will garner punishment where citizens defy them. Understood this way, the role of a representative and the legislative process is inherently entangled with conscience. So the nature of lawmaking and what is at stake in this domain strongly suggests that conscience should be front and center in the work of lawmakers. Yet it's usually, especially on the agency model, I think, deemed foreign or alien to their role. The agency model, apart from the democratic deficit that it seems to create, also in a certain way dehumanizes lawmakers by viewing them as more like cogs in a machine. This residual practice of labeling votes on certain pieces of proposed legislation free votes appears to be a way by which the agency model has sought to accommodate or make allowances for the moral integrity and identity of lawmakers. But the generally ad hoc nature of this practice, at least in certain jurisdictions, has not provided a stable mechanism by which to safeguard those interests. So to wrap up this section before I move to my final portion, the inherently normative nature of lawmaking, coupled with the status of freedom of conscience as a fundamental human right, suggests that lawmakers should always be free, certainly be more free than they are now in many jurisdictions, to decide whether, in their estimation, the proposed legislation in front of them is the right path for a society to take, the right path, normatively speaking. The determination of the rightness of the path may, depending on the circumstances and context, be informed from the standpoint of their constituents, country, conscience, or a combination of those interests. But it's injurious to democracy, and in some cases to the representatives themselves, owing to their human dignity, to exclude conscience, or to largely exclude conscience from the legislative process. Moving to my final kind of reason as to why I think conscientious representation is the way to go. Conscientious representation means more than merely allowing lawmakers to vote for legislation in line with what they believe is the normatively appropriate path for a society to take. Rendering free votes commonplace within liberal democracies would also facilitate the expression of viewpoints on proposed legislation that would otherwise not be aired due to the threat or specter of party discipline. If a lawmaker can vote freely, it's hard to justify barring the lawmaker from expressing his or her views on why the proposed legislation should or should not be enacted. If the quality of debate on public policy stands to benefit from normalizing free votes, it's not outlandish, in my view, to suggest that the legislative outcomes that follow these debates will be superior in light of having taken into account a broader array of voices and concerns that are affected by the proposed legislation, whatever it may be. At a more structural level, the normalization of free votes, indeed I'm calling for their standardization, within electoral systems dominated by political parties may also reduce the instances in which citizens deem themselves unheard within the legislative process or ineligible to participate more directly in it by running for office. Now, one might argue against granting greater room for conscientious expression in legislatures by appealing to majoritarianism and public opinion. The expression of views by lawmakers that diverge from the positions taken by the leadership of their political party, in other words, should not be accommodated on this view, where those opinions happen to either depart from the view of the majority of the party membership or the majority of the society that the Legislative Assembly represents. But to that argument, I'd say there was a time when the majority view on any given issue was the opposite of what it is today. This majoritarian argument would mean that a politician who favored the abolition of slavery at a time when that view was highly unpopular would not have been able to advance that view because of where most citizens stood on the issue at the time. And so history is replete with examples of societies exhibiting confidence, and as it turns out, overconfidence in the righteousness of laws that have, owing in part to the conscientious advocacy of politicians and others, been discredited and eventually abandoned. I think of Martin Luther King, for example, and William Wilberforce with respect to slavery. There are a variety of examples where conscientious advocacy played a major role in transforming societies for the better. History has taught us time and again that we should refrain from sidelining conscience in the realm of lawmaking and public policy. Why? Because human beings are fallible, and for that reason alone, there's almost always value, I believe, in allowing citizens and their elected representatives to express views that happen to diverge from the prevailing orthodoxies of the moment. Majority rule, if overemphasized, also impoverishes the functioning of legislatures and the vitality of democracies. Majorities, of course, matter in terms of which laws are ultimately enacted and not enacted, but the debates that precede that vote, or those votes on proposed legislation, ought to be as robust and nuanced as possible. As mentioned earlier, legislatures decide the basic rules for a society: what's allowed, what's not, what will occur when what is not allowed comes to pass. In that light, democratic legislatures are venues in which freedom of conscience, that is, the freedom to speak and vote for what you believe is in the best interest of a society, should be broadly granted. Legislatures are not the place to effectively censor certain viewpoints on account of their unpopularity. Put differently, it's hard, for me at least, to perceive the downside that would follow from allowing lawmakers to not simply be free to vote conscientiously, but also to be free to express themselves conscientiously, at least more so than they are allowed to do so now. From the perspective of seeking to craft legislation that reflects the myriad considerations that might be at play in respect of even the most seemingly simple policy issue, why should a political party bar an elected member of the same party from speaking publicly in a manner that departs from the official position of the party if that member feels that that needs to occur? This scenario in which a lawmaker wishes to publicly disagree with a position of his or her party on a specific piece of proposed legislation or a position on a particular issue differs from the scenario described earlier in which an individual runs, or differs from the situation where an individual runs for office under the banner of a party on one side of the spectrum, but turns out after the election to be in fact a proponent of positions and principles that fundamentally differ from those adopted by the party in question. The scenario I'm describing here is a lawmaker who agrees with the lion's share of the positions taken by his or her party, but happens to find him or herself unable to agree with the party on a particular issue or small set of issues. So if legislatures are essentially concerned with enacting laws that aim to benefit interests such as the common good and to facilitate a just and equitable society, there would need to be compelling reasons for stifling the breadth of the discussions and debates that inform the content of these laws. It seems to me that if there's a venue in society in which freedom of expression ought to be maximized and prioritized, perhaps a university is right up there as well. A legislature would arguably be it. Representative democracy, it's also important to note, is already, in a certain sense, a sacrifice in terms of democracy understood as the people ruling themselves. What I mean by that is direct democracy, in which the people themselves, as the whole collective, enact legislation rather than choosing representatives to handle that task, would enable a more direct connection between the people and the laws that govern them. That form of democracy would, at least theoretically, allow for the submission of a wider array of concerns and interests being inputted into the legislative process. Now, the obvious administrative challenges created by direct democracy make representative democracy a sensible and appropriate alternative. The point being made here is that, absent compelling justification, care should be taken to avoid further sacrifices to ensure the voices of the people are heard in the legislatures that govern them. Now, I should, before closing and getting into just my concluding remarks, there are, of course, options that a lawmaker could take other than publicly criticizing the official position of his or her party. And in most cases, I think lawmakers will likely choose these other options. The lawmaker could, for example, keep quiet, say nothing. The lawmaker could seek to change or refine the party's position by having internal discussions with the party on the matter. Finally, if the matter comes to a vote and the party's position remains unpalatable to that lawmaker, he or she could abstain from voting rather than breaking ranks and voting in a manner that publicly deviates from the party's position. So there are other options. Be that as it may, there may be scenarios in which the lawmaker feels compelled as a conscientious representative to publicly criticize the position taken by his or her party, or unable to publicly defend the position at issue. The lawmaker may conclude in those situations, depending on the issue in question, that the stakes are simply too high to remain silent or do nothing. In the full version of this presentation, I used the SNC-Lavalin affair as a case study of this, and particularly the actions of Jane Philpott, who wasn't directly involved in the situation in that affair, in the SNC-Lavalin affair, but she decided that she just couldn't continue remaining in the cabinet of the Prime Minister, and left and was ultimately ejected from the party, ran as an independent in the next election and wasn't re-elected. So I view that as an example of, I think, an unfortunate result from the perspective of conscientious representation, that she wasn't allowed to remain in the party, which she wanted to do, just wanted to leave cabinet given some considerations at that level. So to conclude, in these remarks, I sought to challenge or test the prevailing theory of representation in most liberal democracies, which understands elected representatives as agents whose mandate is to enact the manifesto of their political party. Lawmakers, in my view, should be allowed to speak and vote on what they believe is in the public interest or what will promote the common good, whether their beliefs on these fronts align with the official position of their party or not. Now, in most instances, this call for change that I'm making, if taken up by political parties and democratic institutions, I actually think will not alter the present reality in which most politicians vote by the official position taken by their party on an issue. What I mean by that is, at present, politicians who belong to a particular party vote for the positions taken by their party because they actually conscientiously agree with those positions. These votes are, in a sense, already free for these politicians. They don't require the prospect of discipline to bring them in line. What the change I'm advocating for here will yield, however, is the freedom for lawmakers to part ways with the party line and to do so without the risk of punishment where they find themselves unable, for conscientious reasons, to follow the path the party has taken. As for how this change would or could come about, the most straightforward option would be for party leaders to flip the switch, so to speak, from the agency to the trustee model of representation, or at least flip the switch, maybe if it's like a dimmer, maybe getting closer to the trustee model than where they are now. Assuming that the constitution of the political party empowers the leader to take such a step, this would be the quickest way to secure or achieve conscientious representation. If the constitution of the party doesn't grant that kind of latitude, the party itself would have to adopt something resembling conscientious representation as an operating or a guiding principle of that party. Another option would be for legislatures themselves to amend existing laws that regulate political parties, or enact laws that do, if no such laws exist, and include provisions that constrain or at least regulate party discipline. Or legislatures could amend their internal rules or parliamentary laws to give greater room for conscientious representation. For a variety of reasons, including potential litigation as to whether such provisions would violate constitutional guarantees of freedom of association, which political parties benefit from, the internal pathway, if I can put it that way, the internal in-house solution to conscientious representation would appear to be the preferable avenue by which to reach this outcome. So my position, just to close, my position may come across to some as calling for an unrealistic or even utopian form of politics, a romanticized vision of liberal democracy. Now, there's no question that the vision of legislating that I am articulating is an uphill climb in many jurisdictions. To realize this vision, a sustained and significant dose of goodwill and effort would be required. But the notion that this vision is out of reach altogether as a matter of principle, to my mind, does not ring, or to my ear, does not ring true. Critics of Edmund Burke's vision of representation have disagreed with it for many reasons, but impossibility has not led the charge in this regard. Even if no liberal democracy ever manages to perfectly reflect this vision, there's surely something laudable to be said for any jurisdiction that manages to at least move closer to it, at least in my view. So in Robert Bolt's A Man for All Seasons, Sir Thomas More says that when, quote, when statesmen forsake their own private conscience for the sake of their public duties, they lead their country by a short route to chaos. This statement rightly suggests that allegiance to conscience is, in my view, actually a duty of an elected official. What little space exists for conscientious representation in liberal democracies should not be further reduced, nor should the status quo, in my view, persist. More space for representation of this sort should be created. Political parties should continue to convey how they expect their members will vote on most issues, and members will almost always vote in line with those expectations. But the door should not be, in my view, shut on the freedom of members to vote otherwise if they believe it's the right thing to do. So the result may not be as disciplined a form of party politics, but it will be far more democratic. Thank you very much.
Thank you, Brian. Everyone hear me? Thanks so much for that. I appreciated many things about it. I appreciated the organization, the conciseness of your thoughts, which made it possible to follow even without slides, and kind of the gracious way in which you argue for something very much other than the status quo. So thank you for that. We have about 15 minutes or so for some questions. So
Sure.
we can get some questions on Zoom. We can get some in the room. Well, we have a few already. So we'll go Paige and then Abigail.
Great.
Online.
Hi, Brian.
Hi.
Thank you for that. I'm curious if you think that there's more protection or social acceptance for people's conscientious objections when those objections lean left, as opposed to if the source of them is conservative or traditional values. And if so, how is that influencing lawmakers, the courts, even universities?
Yeah, it's a great question. Is it kind of an uneven approach depending on where the kind or the nature of the conscientious objection? If it is, I mean, I wish I had kind of data or some sort of study on that. I think there's something to what you're saying, absolutely. But I think it's a call to say that this is supposed to be something that's evenly applied and evenly enjoyed. So to the extent that, and maybe it is something that's just subtle and hasn't been fully kind of brought to the surface and realized. Well, what's interesting about conscience and why the subject is near and dear to my heart and why I wrote my doctorate on it is it's something that all human beings enjoy, regardless of whether you find yourself kind of quote unquote conservative, liberal, left, right, whatever label you want to use. And so it speaks to, and I just very much just brushed up against it, this idea of human dignity, integrity, who I am and what I stand for in a fundamental sense. So I suppose what I would respond is that it's a call to recognize that it's a kind of a fundamental human right that should be granted and equally respected regardless of the kind of what your conscience, it's not kind of qualified by kind of what kind of a conscience you've formed. So I think it's fair to say that maybe at some level there might be, and this you could probably look at different eras where there was more respect for certain invocations of conscience, certain conscientious views rather than others. But I think that my response here is it's a call to try to even that playing field, if I can put it that way. So I appreciate you raising that. Yes, I wish I had data to kind of substantiate, but I think it rings true what you're saying, or resonates with me.
Thank you very much for that interesting talk, and it brings back my Canadian politics day. So one of the ways in which party politics is taught at the first year is, especially parliamentary party talks, is that there's a contrast made between Canada and the United States. And that contrast goes something like this, is that to think about the Canadian system like the American system is both really fails to comprehend and I'm just putting it this way, the great virtues of the parliamentary system, which is that it's not run on the basis of individual lawmakers. It's based on the idea of teams.
Yes.
And the teams work collectively, and everybody has a different role, and they agree on the play. And a lot of the debate is internal. And that's the vision that we want the students to have. The virtue of that is the virtue of teams, that a lot of the disagreement gets dealt with internally, and that people there is never a door shut to dissent, but you have to leave the team
Right.
if you don't want to play the game. So that's one sort of pressing you back
Yes.
on conscientious lawmaking. The other is that the other aspect of this that is attractive is that in the real world, individuals are subject to a great deal of lobbying. And the American system is corrupted when individual lawmakers are basically bought off by powerful lobbies. People don't vote their conscience.
Right.
They vote the way they're paid to vote. So rather than being under the umbrella of the team conservative or the team liberal, they're under the team, IBM or whatever they are.
Sure.
So Canada doesn't have the problem of lobbying in the same way, or at least the problem we have is more controllable than it is in the United States. So and I hate to do this because I know it's more than one question, but the other aspect of this, the terrible complication, is that parties are private organizations. So they can do what they want.
Yep.
In a sense, they just happened in I mean, that's not an objection to your view. It's just a massive wrinkle in this whole thing. So if they want to make the rules one way rather than another, it's really not in the Constitution of Canada. I mean, it's beyond the purview of the Constitution of Canada, what they want to do. So anyway.
Absolutely. Well, thank you for those points. And yes, indeed, I think I definitely appreciate starting with the last comment that it's indeed outside of, these are private organizations, associations, so they're not governed or bound by the charter. At the same time, they play obviously a major role within lawmaking. And I think it's interesting, it seems open to me that if, just take a parliament in Ottawa, they wanted to change internal procedures just such to say that it's illegal or impossible or unlawful for discipline to be meted out by a party if a member of a given party votes against the party line. I think there would be the ability for the party for the parliament to change its internal rules, or even to pass legislation, as I kind of alluded to at the end, constraining parties in terms of how you would enforce that is a whole other issue, of course. But that itself would raise some constitutional considerations, namely the freedom of association, which political parties benefit from. So there is indeed a balancing act. I completely agree. And just kind of building off of that, this idea of the team. Hopefully it came through in the presentation, but I definitely see the value of that of political parties in terms of the team effort. So I think I'm probably calling for something that's a bit more at least balanced than when it seems right now, especially in Canada, as being a very party driven. Political parties have a tremendous amount of power. One example, when I was writing this paper last summer, it was around the time when Boris Johnson fell from power in the United Kingdom. And it's striking to me that occurred through the decisions of his own party, of his members, the Conservative MPs banded together and said, no, we don't want it anymore. And to me, it was interesting in terms of the comparative between Canada and the UK, to Westminster parliamentary systems. That notion of, maybe I don't know if it's the current government, but I think it would apply more generally, just we have a different, much more stringent form of party discipline. The notion or prospect of that happening in Canada, of members of the Liberal Party coming together and saying, Prime Minister Trudeau, we want you out, just struck me in the moment, kind of a little comparative moment last July or whenever it was, as just being unthinkable. So the political cultures, I think, matter as well. You mentioned kind of Canada, the US, absolutely, all those points well taken. But even within the Westminster parliamentary world, some pretty big differences in terms of political culture. And the final thing I'll say is, these are all terrific points, I appreciate you raising them, is party discipline indeed is just one form of pressure that might impinge or kind of press on or bump up against the conscience of a politician. There could be pressures outside of the realm of what parties are doing. It could be outside actors such as big interest groups, for lack of a better way of putting it. You mentioned IBM or whatever it might be. So absolutely, conscientious representation would call for basically not having one's conscience, in theory, be impinged by that. But it's a balancing act, absolutely. So all those points well taken. I appreciate the pushback and the commentary. Thank you.
We have a question from Zoom, so I'm going to
Please.
unmute Conrad, and Conrad, you should be able to go once you're unmuted.
Hello, I'm Conrad Brunk. I was a former director of the center there. And about 50 years ago, I wrote a doctoral dissertation at Northwestern University on the concept of the right to freedom of conscience. And I never published it. And there are a lot of reasons why I didn't. One is I don't agree with a lot of it now. But what I want to say is that the way you laid out the issues in the first two parts of your presentation seemed to me to be exactly right. I agreed with you entirely, especially in part two, where you talk about the problem of what counts as an issue of conscience. And you laid that out exactly right, I thought, and I really appreciated it. But I do have one minor question for you, and that is that the argument is often made that the place where the conscience of the party member can be represented is in the party caucus, in the discussions around the development of party policy. And there you speak your conscience, and if you lose, you recognize that that is the will of the majority in your party, but still that's where your conscience is represented. You didn't mention that, I don't think, in your presentation. Would you care to comment on that, please?
Thank you so much. Was it Conrad? Thank you so much. That's great. A really, really important point that has only really come onto my radar after writing the paper through your question, but also just in conversations with others who are kind of in this realm. And I think that's a very good point. To what extent is there actually more conscientious representation going on than I appreciate? And part of the problem, I suppose, is, or the challenge, is that kind of what happens within caucus is, of just generally speaking, it feels like a bit of a kind of a conclave, or it's not kind of publicized what's happening. So it's generally kind of off our radar, or not on our radar as much as maybe we would appreciate. So I completely take your point that maybe that is a place actually where more conscientious, or an example of how conscientious representation is perhaps more alive in even a place like Canada, where there's a very stringent form of party discipline than I account for. So I totally take your point. I think it's an area where I need to dig in a bit more. And then there's this question of, if at the end of the day, as you rightly put it, if your position on a given issue that's voiced internally within caucus loses or doesn't win the day, you have a choice to make. What do you do, and at what point can the party say that you require you to toe that line, and at what point is it okay for you to maybe abstain, et cetera, et cetera. So I completely take your point, Conrad. It's just an area that I haven't thought too much about because it only recently came onto my radar, and I appreciate you putting it on again. I think that is a really intriguing area as to whether conscientious representation is actually perhaps more alive than I have given credit for. So thank you for raising that. I appreciate it.
Thanks for that. And just while we're moving the microphone, I think it raises a question about whether it's important for the exercise of conscience, to be public, right? Or if it's enough for it to be public. Because I heard in your comments that there was something about the publicness of it that's important to you. And so maybe that
it's not enough.
That doesn't, anyway, something to think through. Yes.
Am I correct in understanding your thesis that conscience is presumed to be good? And I'm wondering what if my idea of conscience gives rise to what you recognize as apartheid or something else?
It's a very good point. In the full version of the paper, which I had to pare it down a bit, I did have a section early on in which I completely admit that the phenomenon of an errant or ill-formed, or we can say severely ill-formed conscience leading to convictions that many, if not the majority, if not the overwhelming majority, would say are odious or are incorrect. That's definitely a part of the puzzle. So I don't know if I would say that I think inherently, whether I think conscience is good or not, I think it's just a feature of our humanity, of human beings. But it can absolutely lead to, if it's either ill-formed or just not formed in a way that I or you might think is appropriate or proper, could absolutely lead to an errant conscience. So that is indeed a part of the mix. And I don't know what more to say other than it is a part of it. So I think the risk maybe that you're gesturing to is that if we allow conscientious representation to kind of be turned up in terms of the volume on that, would we perhaps be opening ourselves up to the risk of errant conscience or errant consciences winning the day? I suppose there's absolutely a risk that could happen, although I think it's also a risk of in the current system as well, where you have perhaps a party leader or a very small group in their consciences, of course, taking certain positions. So I think it's just a feature of our humanity that flows from or is a part of this kind of intrinsic element of who we are in terms of our conscience. It can lead to errant, incorrect, even maybe people would agree are odious convictions. So I absolutely agree. It's in the full version. So I'll have to share that once I have it published.
All right, I think we've got time for one more question.
Yeah, I had like a few questions, but maybe I'll just force you to kind of like give your opinion about a very particular thing, if you'd be willing to do that. And it may end up being controversial, who knows? So in terms of, because you were talking a lot about democratic deficit that exists, you're trying to like in some way overcome. And when we think about the kind of history that exists in how like these states that we exist in, like parliamentary states exist, like they're designed to have a democratic deficit. Like that's from the very beginning, they're supposed to be anti-democratic. They're supposed to keep out the demos from ruling itself because there are only particular people who can rule. And so I like that you brought up the direct democracy things. I'm just wondering if maybe in your mind that direct democracy is technically better and that's like actually what should be striven for, especially given like technology, like maybe we could overcome some of the administrative issues that you said might be a problem.
Right.
Or that maybe, because you'd also said that you want to have kind of a balance between conscience and party discipline. So maybe you're kind of leaning towards that. Yes, we should have democratic deficits and they are actually fine. And so maybe if you want to take a stance on where you see yourself.
That's a great question. I mean, I think I truly, honestly haven't thought too much about or reflected too deeply. And I'm going to reiterate, yeah, definitely I'm already outside my lane by doing a bit of political theory as a kind of constitutional law scholar. So forgive me for any errors that I've made in this foray into this area. But I think my reflection on direct democracy, at least in the piece, is more just kind of recognizing that, as you well put it, there's already a kind of a built-in or an arguably accepted deficit that we've taken by saying, okay, we're going to use representative democracy. I think arguably, or mainly, as I understand it, for administrative efficiency reasons, especially when you're talking about governing an entire huge country as opposed to perhaps a small municipality. Or in any event, I think I'm saying representative democracy. I think those built-in deficits I'm comfortable with. I just think that when now that we've decided to go this way, or that we have decided to go this way for centuries in our tradition, at least in Canada and other liberal democracies, let's try to make it let's optimize it as much as possible through, I think, this balance that Edmund Burke, I think, quite rightly put forward in terms of the balance between one's conscience, one's constituents, one's polity, whatever it might be, a city, a province, a country. So I think my kind of instinctive reaction is to say that I'm comfortable with the deficits, but I never, and as I mentioned, there's indeed a sacrifice that's already been made by virtue of choosing representative over direct democracy. So I guess I'm comfortable, I have to think about it more, I'm comfortable with that deficit at least, but I say we shouldn't make further sacrifices or too many further sacrifices. And I think by going with the agency model, we are making further sacrifices upon sacrifices.
Thank you. Well, I think that's about all the time that we have for tonight. So I'd like you to join me thanking Brian for a really engaging talk.
Thank you very much. Thank you. Wonderful questions. Thank you.
Yeah.
And I'm sorry that I didn't mean to be, the shortness of my answers wasn't meant to come across as dismissive. I just know we were short on time and I wanted to try to be so wonderful.
You knew I had the hook.
That's right. I'll see if there's still time for me to make some edits before this goes to print based on these wonderful comments. So thank you so much for that. I really appreciate it.
Thanks very much. And we have a few new people, I think, in the room. So I'll just plug that we have these public lectures almost every Thursday. They range greatly from political science and law to really, anthropology, anything that has to do with kind of the intersection of religion and society. And next week, as an example, we've got one of our current graduate students, Tanya Britton, talking about the role of talismans in politics and religion in modern Japan. So something quite different, but also interesting, and it would be great to see some of you out again. So thanks very much.